Law. The state cannot legalize an act. It can only prohibit it by law or leave it alone. Traditional justice is based on the concepts of right and wrong. Modem justice on mental health and illness. Faced with two women, both of whom claimed to be the mother of the same child, Solomon talked to them, listened to them, and awarded the child to the woman who he inferred from the information he obtained was the real mother. A modem American judge would proceed quite differently. Faced with two such women, he would conclude that one of them must be deluded. Then, he would order both to be examined by psychiatrists, who would duly discover that one of the women is a fanatic, insisting that she wants the whole child or nothing, whereas the other is reasonable, willing to compromise and accept half a child. Accordingly, the psychiatrist would declare the real mother to be suffering from schizophrenia and recommend awarding the child to the impostor, a recommendation the judge, respectful of the findings of medical experts, would rubber stamp. An old proverb cautions the would-be lawmaker not to prohibit what he cannot enforce. Modem American lawmakers follow the opposite rule. They are most zealous to prohibit that which they cannot enforce. If the person who breaks the law is not punished, the person who obeys it is cheated. This is why lawbreakers ought to be punished, to encourage law-abiding behavior as useful and to authenticate it as virtuous. The aim of the criminal law cannot and must not be correction. It can only be, and must be, the maintenance of the legal order. Punishment is now unfashionable. Why? Because it creates moral distinctions among men, which to the democratic mind are odious. We prefer a meaningless collective guilt to a meaningful individual responsibility. There can be no humane penology so long as punishment masquerades as correction. No person or group has the right to correct another adult. Only God does. But persons and groups have the right to protect themselves by means of punishments, which may be as mild as a scolding or a small fine, or as harsh as life imprisonment or death. Biological psychiatrists claim that mental diseases are caused by, or are the manifestations of, underlying bodily diseases, as yet undiscovered but waiting to be discovered by progress in medical science. If this proved to be true for some or all mental diseases, it would only add more items to the existing list of organic diseases whose treatment patients are free to reject. Hence, evidence supporting the organic etiology of so-called mental illness would display rather than dispel the moral and political dilemmas of coercive psychiatry. Clarence Darrow is supposed to have said that he was for divorce because he was against murder. It is indeed better that husband and wife divorce than commit violence against each other. Similarly, wouldn't it be better for psychiatrist and mental patient to divorce instead of commit violence against each other? In other words, instead of the psychiatrist being allowed to injure the patient with commitment and the patient the psychiatrist with litigation for false imprisonment, each would be allowed to sever his relationship with the other. Such an arrangement would preclude the psychiatrists violating the patient with what the psychiatrist calls treatment, but the patient experiences as assault, and the patients violating the psychiatrist with what the patient calls self-defense, but the psychiatrist experiences as assault. I contend that psychiatric incarceration is always and necessarily a violation of human rights. Why? Because the psychiatric jailer, unlike the penological jailer, claims to be, and may sincerely believe himself to be, a legitimate double agent protecting the patient from himself or from mental illness, and society from the patient. Insofar as the psychiatrist is accepted as serving the patient's interests, the patient is deprived of legitimizing his grievance against the psychiatrist's treatment. Insofar as the psychiatrist is accepted as serving society's interests, the psychiatrist is protected from legitimate criticism for depriving the patient of his liberty. A court of law can be one thing only, an organ for legitimizing coercion. It cannot be what activist judges and their sympathizers want it to be, an organ of benevolence or social justice. Hence, it is that court-ordered remedies for social ills, such as mandating treatment for involuntarily hospitalized mental patients, cannot solve but can only aggravate the problems they ostensibly seek to ameliorate. The very act of speaking of protecting the civil rights of mental patients is an injury to their civil rights. For just as speaking of the civil rights of slaves implicitly legitimizes the legal distinction between slaves and free men, and hence deprives the former of liberties and dignities enjoyed by the latter, so speaking of the civil rights of mental patients implicitly legitimizes the legal distinction between insane patients and sane citizens, and hence deprives the former of liberties and dignities enjoyed by the latter. Not until a free people accept and demand that civil rights be independent of psychiatric criteria, just as they now are of religious criteria, and not until legislators and jurists deprive physicians, and especially psychiatrists, of the power to exercise social controls by means of quasi-medical sanctions, will the civil rights of persons accused of mental illness be protected. For years, American health authorities have been promoting the use of condoms as a means of practicing safe sex to prevent both AIDS and unwanted pregnancy. Yet many local ordinances in the United States, for example, in Syracuse, New York, continue to prohibit the sale of condoms through vending machines or from anyone other than a licensed physician or pharmacist. Violators could be fined $150 and imprisoned for up to 150 days. The law is not enforced, of course,